The sparks flew and the judges were not happy as we saw oral arguments for the second time at the Ninth Circuit Court of Appeals for Junior Sports Magazine versus Bonta. This is our challenge to Assembly Bill 2571. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we saw some more sparks at the Ninth Circuit, and while Judge Lawrence Van Dyke was in the room, they weren't necessarily coming from him. Of course, I'm talking about our Junior Sports Magazine versus Bonta lawsuit, which is our challenge to Assembly Bill 2571. To walk us through that today, we have brought back Anna Barvir, who is a partner at Michel and Associates. She's the one writing this lawsuit, guys, so getting the information directly from the source here. Anna, how are you today? Thanks for being with us.
I'm doing really well. Thank you for having me this morning.
Absolutely. And guys, before we get into this today, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms to get the information as far and wide as possible. It's a great way for you to directly contribute to litigation like this, protecting our Second Amendment rights. So go ahead, like, share, and subscribe. Throw comments down below. It all helps, and thank you guys very much. So, Anna, before we get into the fireworks that we saw yesterday at the Ninth Circuit, let's go ahead and do a little bit of review, maybe for those who haven't been following along on this. Let's just catch everybody up. Can you walk us through what is Assembly Bill 2571 and what is our challenge against it?
Well, thanks for asking. So AB 2571 was a bill that passed on an emergency basis a few years ago in response to some advertising of firearms that members of the legislature and our governor deemed untoward, that were aimed at in their perception aimed at minors, so children and youth. And so the law that they passed on an emergency basis prevents firearm industry members, and only firearm industry members, and that means not just like manufacturers or sellers, but also organizations like CRPA that are formed for the purpose of promoting and encouraging and advocating for the purchase of firearms. It bars those people or those organizations and those businesses from advertising, marketing, or arranging for the placement of advertising or marketing communication that seeks to offer or promote firearm-related products if those advertisements are designed or intended or reasonably appear to be attractive to minors under the age of 18, regardless of whether they're also attractive to adults. So, and then what it also does is prevents any of those firearm industry members from keeping subscription lists or information about minors that would receive their advertising or contacts for the purpose of then marketing or advertising to those minors firearm-related products. And we brought an immediate challenge to that, to the passage of that law on First Amendment grounds immediately after the law was passed to prevent the law from taking effect and to make sure that the firearm industry, including organizations like CRPA, could continue to make pro-firearm speech to young people who are interested in hearing that speech.
And guys, this was a really nasty bill. For those of you who have been following along, you might remember when we did file this lawsuit, the state actually came back and tried to write in some exemptions to this law, helped out a couple people. Obviously, that wasn't enough, though, which is why we continued the pursuit on the lawsuit itself. But this one threw the firearms community through a loop. You had ranges that were now worried about having a SIG flag on a chain link fence because they didn't know if they would get a $25,000 fine per every youth who saw it. It threw a lot of the youth programs in California. It brought them to a complete standstill. Programs were not going on. There was a lot of hesitation in the community, a lot of lost opportunity for education of youth also. So definitely good that we're getting the progression and ultimately, got the injunction. A lot of stuff went back to normal while the law's not being enforced, but a bad law in that of itself for sure. So, really two other things before we get into the actual oral arguments that happened a couple of days ago. First of all, this has already had a little bit of an interesting path through the court system, up and down, up and down. Could you walk us through that from start until now, which I believe is the second appearance in front of the Ninth Circuit that this lawsuit has seen? And also, can you speak? There is another lawsuit, right? It's the SCI lawsuit that's been running in parallel. Can you kind of give us the overall picture of how these have gone through the court?
Of course. So you mentioned correctly that pretty much immediately after our lawsuit was filed, we were contacted by the state. Oh, we're going to amend this bill, and it became AB 160 that would write in some exceptions so that organizations and junior shooting groups could make sure they could still hold their educational events, though it still kind of affected their ability to have competition events that rely on sponsorships, because they still couldn't have ads from sponsors at those events, right? But when that happened, when that bill got introduced, the state immediately asked the court to hold off on our preliminary injunction motion, continue briefing it, hold off on ruling on it until we get this passed. We think it'll pass. And it did. And the court then heard our motion for a preliminary injunction and denied it entirely. We then took that denial to the Ninth Circuit Court of Appeals, fully briefed it. We argued it before a 3-judge panel, including Judge Van Dyke, Lee, and Smith. And after that, pretty quickly after that, got a 3-0 opinion saying that the plaintiffs had proved that they were likely to succeed on the merits of their First Amendment claim, that AB 2571, even as amended through AB 160, was likely to violate the First Amendment. And it said that in clear language, section 22949.80 is likely unconstitutional. It didn't really get into the specific subsections. It says we had made our burden on that. At the same time, and heard the same day, was Safari Club International's similar lawsuit challenging AB 2571 on First Amendment grounds. Our case was heard first. They came up, then SCI was heard second, and they kind of like did some cleanup. It made some points that didn't get to be made during our argument. It was a really nice, two arguments back to back. Our junior sports, kind of, since it was the lower numbered case, heard first. We got the long decision, and then they came back with another opinion, said yes, in SCI, same applies that we said in junior sports magazines. And so both then cases were remanded to the district court for further proceedings in line with what the Ninth Circuit panel said in the first appeal. A lot of wrangling happened, but ultimately what happened is, in the Safari Club case, Judge Drost in the district that they were in said, okay, and accepted a preliminary injunction that the parties came to together. The state and the plaintiff's attorneys filed a proposed injunction, preliminary injunction. The court said, yep, granted, and joined the entire law. While on the other hand, suddenly, after that happened in Judge Drost's court, the same attorneys, the same state attorneys who were defending the law in Safari Club are defending it against us, and then came to us and was like, actually, we think that subsection B of this law was not part of the Ninth Circuit panel's opinion, and you're going to have to file a motion with Judge Snyder in the Central District to get the whole law enjoined. We were surprised. That did not, because they had never made that argument before at any point. Even when they went up to seek an en banc hearing, they didn't tell the court that they thought this case should be that this law should be severed, that any of it was savable. They agreed that the entire law was at issue, and that was what the court decided, and the Ninth Circuit decided. Ultimately, Judge Snyder agreed with the state's argument and only enjoined subsection A and the portions that rely on it, and left subsection B intact. And that made us, so now we have to appeal again to the Court of Appeal to get the entire law enjoined. Even though that's what we had been asking for from the very jump. We filed our appeal and also immediately requested that, because this appeal is going to rely on what happened in the first appeal, we asked the Ninth Circuit to treat this as a comeback case and assign us to the very same panel who gave us a 3-0 win before. And they granted that motion. Briefing ensued, and then we get to yesterday for oral argument. Safari Club International, ultimately what happened in that case was Judge Drost heard about what happened in our case, by Judge Snyder, and clarified its opinion to say, actually, I didn't mean to also enjoin subsection B. The state's right about that, and then pulled back on its full injunction and then left intact the same injunction we have. The Safari Club case didn't appeal that decision and have been waiting on a motion for judgment on the pleadings since December, I believe.
So a little bit of a deviation in the path, but ultimately both lawsuits ended up kind of in the same place, having an injunction on subset A without having an injunction on subset B. I am kind of curious, last thing I promise before we get into the oral arguments yesterday. This was kind of frustrating to me when it happened. You appeal to the Ninth Circuit for a preliminary injunction. Logically, you kind of think their answer will be yes or their answer will be no. I feel like we didn't really get that the first time around from the Ninth Circuit here. Instead, they said, we see everything that should be seen to grant this injunction, but we're going to put it back down to the federal district court so that they can grant the injunction. Why does that happen? Why? I guess in hindsight, you're kind of thinking about this clarification issue. If they had granted the injunction in the first place, would we even be having the conversation that we had a couple days ago?
That's not really how appeals of preliminary injunctions work. Now, what you have seen in the past is when either party that loses goes up on appeal and seeks an emergency stay or an emergency injunction from the Court of Appeals of the lower court's decision, then the Ninth Circuit can do that, can issue its own injunction. But those are generally temporary for the length of the time that the appeal is ongoing. They don't tend to issue their own injunctions. That's the purview of the district court. So what the Court of Appeals is going to do is decide whether or not the lower court abused its discretion in denying or granting the preliminary injunction motion, and then tells the court below what it has to do in line with its decision. Now, you could seek a writ of mandamus where the plaintiff or whoever is appealing is asking that higher court to tell them they have to issue the preliminary injunction. But generally, that's not the first thing you're going to do until it's shown that the lower court isn't going to do what it was supposed to do, that the higher court told it to do. And so in this case, we did really ask for more clarity from the Ninth Circuit to tell the lower court what sort of order to issue, but it isn't normal that the Court of Appeal would issue its own.
I see. So yeah,
preliminary
needless
injunction.
to say, that is not a deviation from the process. That is the process, which leads us to Tuesday when we had these oral arguments. It was a little bit spicy, actually, Jacob. We got a little compilation specifically on subsection A and B and the conversation with the panel of judges with the state's attorney. Jacob, if you can roll that now, let's take a look.
Conduct.
Now, just a minute. That's suggesting that it does, but let me ask you, did you ever argue, prior to getting back to the district court, that there was a separate part of this statute, that the statute had separate parts, that there was somehow the statute could be severed? Did you ever argue that before getting back to district court?
I have two-part answer to that. The first part is that it was.
Well, answer my question.
Yeah.
Did you ever
Yes,
do it?
I will. Well, the answer to
No.
that is, well, may I say why I don't think that's relevant, though, Your Honor?
But I
May
think
may
it's pretty
explain?
relevant, but I just want you to ask why did you ever do it?
Because, Your Honor, it was
Now, I'm not asking you why did you do it. Did you ever do it? Did you ever ask to sever B from the rest of the statute?
It's presumptively severable, Your Honor, so
Well,
it does not matter whether we
presumptive-
argued it.
Well, now, just a minute. I've got Committee de Generaleros de Rondo Beach. I've got IMDB Com Inc. versus Becerra. Both of those say that when someone doesn't argue severability the first time, when they don't argue it, they waive it, and it's done, and we don't consider it again. Name me one case where a person who comes to my court and is arguing something in front of me, and doesn't argue that it's a part of the statute that ought to be severed, and then goes back to district court, should be able to come back and then argue that it's severed on reappeal, if you will.
I think that waiver could potentially be relevant had the district court granted the injunction as to both A and B, then it had become before this court, and then the court had addressed it. But the fact is, this court does not appear to have
So what you're really arguing then, Counselor, is that you can defend a statute in front of the district court without ever talking about B. You can then argue a statute and defend that statute in front of this court without ever talking about B, never asking the district court to sever at all, never asking me to sever. But when you get the decision from me on our court back in the district court, then you can ask it to be severed? Is that what your argument?
I am arguing that, Your Honor, because
Where do you find a case that says that? Find me one case, because I looked for it. Give me one case.
if I may explain my answer in a different way.
Well, I just would like a case that tells me that that's what happens.
I do not know of a case, but I would like to explain my answer as to why that's okay.
Okay, you can explain it, but I guess I'm bound by law.
Right.
And I'm bound by precedent.
All right, so a little bit spicy there. Let's even add a little bit more context. I want you guys to have this too. Jacob, let's go ahead and pull up the actual bill as it was chaptered. Let's take a look at subsection A and subsection B. It reads like this. Subsection A firearm industry member shall not advertise, market, or arrange for placement of an advertising or marketing communication concerning any firearm-related product in a manner that is designed, intended, or reasonably appears to be attractive to minors. So you got that as its own thing, and then you've got subsection B as its own part in this bill as well. A firearm industry member publishing material directed to minors in this state or who has actual knowledge that a minor in this state is using or receiving its materials shall not knowingly use, disclose, compile, or allow a third party to use, disclose, compile the personal information of that minor with actual knowledge that the use, disclosure, or compilation is for the purpose of marketing or advertising to that minor any firearm-related product. So, you know, it seems like in the clip, and really the majority of the oral argument itself, it's not on the merits of the case. The judge, and guys, if you want to watch the whole thing, Jacob, let's link the video below. It's kind of interesting just how quickly and smoothly for our side this ended up going, not necessarily for the state side. But if you want to watch the whole thing, watch it in the link below. But I mean, even earlier on, the judge asked the attorney on our side, do we even need to get to the merits of this case? And he was like, no, I don't think that we do. It seems like the real issue being contended with here is the want to sever both of these subsections within the same bill. I'm just wondering, can you break this down for me? Why is the judge criticizing the lack of argument thus far for severability of these two things? And why is it in the state's interest to try and sever both of them?
Okay, so to answer the first part of your question, I think the reason, I mean, it's obviously hard for me to get into his brain and explain exactly why he feels this way or the reason the argument went the way it did. But what I think, and being on our side, having experienced the state telling me that I was meaning to only enjoin subsection A, I remember how I felt when I was told that by the state's attorney. I imagine that the judge is feeling the same way. I helped write this. I know exactly what I meant. It was very, very clear, at least to me, Judge Smith, that we said section 22949.80 is likely unconstitutional. There was no discussion of whether subsection A is separate from subsection B and whether it's different conduct. They took the statute just as plaintiffs did in our briefing and our argument as a whole. And the reason we did that is because subsection A and subsection B cannot be severed. They as much as the attorney for the state kept trying to claim, and she kept bringing this bell, it's totally different conduct. It's totally different conduct. It is not different conduct. And the reason I say that is because, yes, subsection B talks about compiling minors' information, but it's not just that. It's only for the strict purpose of marketing or advertising to those minors firearm-related product, which is the conduct in subsection A that the court expressly found was constitutionally protected and that our clients can engage in. So what happens today, a year after we won, more than a year after we won the first appeal, Junior Sports Magazines, the publisher of that magazine, is still unable to distribute its magazine in California because it can't use its subscription lists, right, of minors in California to send that magazine, Junior Shooters Magazine, to Californian minors. And I mean, think about it. That'd be like saying that, the publishers of Highlights magazine can't keep the information of its, 10, 8 and 9-year-olds in order to send them their subscription. It's absurd. It's patently absurd. Firearm-related products are legal for minors to use in California, and we have a constitutional right to market or advertise to minors, as long as we're not saying, hey, kids, go buy that gun. You can totally do that in California. Obviously, they can't. But educating them about the existence of firearms is protected. So I think the court was really upset to be like, okay, we're here over a year later, making the same, like, you're arguing something that you didn't raise until you went all the way back down. And basically what they're doing is sandbagging plaintiffs by being able to raise any complaint that subsection B was different conduct. We didn't ever see it that way. We always argued it was part of the whole. And so it's not fair to plaintiffs, and it's a waste of the Court of Appeals time to bring that up after the fact, right? And then try to tell everybody what they actually meant was. They didn't. It was very clear.
Well, the court definitely seemed to share in that frustration, and I guess you kind of already stated this, but I'll ask it anyways because the court did seem to be very disappointed with the fact that this appeal was up here again in the state that it was in. To the layman, it seemed like it seems like there is an incoming slap to the state, and who knows? Maybe this is out of desperation because they know that they have a losing argument. But it really seems like this panel is not going to change its previous thoughts on this. So having said that, I'm curious, just overall, how did you perceive the oral arguments? If you perceived it any different from me, and what's really the future? What's this lawsuit look like going forward? Is it going to go up or down? Any perceived timeline there?
So with regard to how I perceived it, I was enjoying it. It's so rare that we get to sit back and enjoy a Ninth Circuit oral argument, to see the state being held to account for the hijinks that it engages in, for the lies that it was engaged in this case specifically. I perceived it personally, it was a joy to watch. I do think, while we didn't hear a lot from either Judge Van Dyke or Judge Lee, I think we have an idea that from Judge Smith how they're all going to go, and I anticipate a win here. What I don't expect in this very specific case is I don't expect that the state is going to seek en banc again. They might. I would be a little surprised if they're trying to delay a lot. That could be just a tactic there, but I don't see that happening, and I definitely don't see this as something that the Supreme Court would take up, because it really, again, isn't about the merits. It's about this severability. It's about waiver of arguments. It's about what a Ninth Circuit panel meant when it wrote its first opinion. So I suspect we'll get a decision, and if it's a win for us, I think that it'll go back down with more clear instructions to Judge Snyder about what she has to do. As I always say, we can never know how long a panel of the Ninth Circuit is going to take to rule, but considering that this is probably, I think the court probably does not think that they have to get into the merits here of subsection B's constitutionality, that they already said that subsection B was unlikely to be constitutional. I expect a pretty quick decision to come down, as long as they're not too overwhelmed with other stuff. So hopefully it'll be pretty quickly, and then it'll come down pretty quickly, and we'll go back down to the district court, get our full preliminary injunction that we've always been entitled to, and then move forward with substantive motions that I think will probably dispose of the case without trial.
Well, as usual, I certainly hope that you're right. And it does definitely seem like the conditions are correct here to get this done quickly. It seems like, we have the support of the Ninth Circuit panel here. If they can provide more clear instructions to get that injunction, the law isn't being enforced. And while it's not being enforced, if we can dispose of it quickly, all the better. Definitely something to follow along with, though, which we will continue to do. One to look forward to being victorious in court soon enough. But Anna, I know that you're busy. Great job on this so far. Looking forward to see what happens next. But most importantly, thank you for taking the time to share with us today. I appreciate it.
I always love being here and being able to talk to you and all of the supporters of CRPA about what our lawsuits are doing, and love to be here. So thank you.
Mutual, definitely mutual, and absolutely. Well, thank you very much. And guys, if you like this kind of content, you want to see more, you want to hear what is going on with this litigation from the attorneys who are working on it, please be sure to like, share, and subscribe to the videos. It really helps with the algorithms. We're trying to get everybody on the same platform of information so that we can continue the ball rolling forward for Second Amendment advocacy here in the state. Thanks again, guys. We'll see you on the next one.